Hi guys, so as you all know, the Ministry of Finance has come up with a notification on 8th June 2020 to decriminalize 19 acts with the basic intent for ease of doing business and improving business sentiments and reviving economic growth and improving the justice system. In this video, I'm going to analyze three acts, the RBI Act, SARFAESI Act and Banking Regulation Act, to see which provisions are being decriminalized. Now moving on to the first section, which is section 29 of the SARFAESI Act, which reads, if any person contravenes or attempts to contravene or abets the contravention of the provisions of this act or rules made thereunder, he shall be punishable with imprisonment for a term which may extend. So it means that if any person contravenes any of the provisions of the act, of the SARFAESI Act, meaning first we need to understand what SARFAESI Act is. So basically, the SARFAESI Act was legislated to assist the banks and financial institutions to take possession of property assets secured against the loans and sell them. So this is a very powerful tool for the banks to recover loan amounts for non-performing assets and defaulted loans without much intervention of the court. However, this particular act has given utmost power to in the hands of these banks, and a lot of times we can see that the banks have misused this law to arm twist and harass the borrowers. So I would like to take the most important provision in this particular act is section 13 of the act, which basically under which the bank can issue notice to the borrower to discharge his loan liabilities within 60 days period, failing which under 13(4) the bank can issue take possession of the property and auction this particular property. Now if the borrower resists the taking over of the possession, the bank can approach the magistrate court under section 14 of this act, when the bank can take assistance of the magistrate to take possession of the asset. Now this section cannot be questioned in any court of law. So as you can see under 14(3) of the act. Now the only recourse which the borrower has is an appeal under section 17, which basically can be taken by the borrower only after possession has been taken, and even a writ proceeding is not maintainable by the borrower as held by many high courts and Supreme Court. This particular law is so draconian that the banks can misuse this law in whatever manner they want. So in one particular case of ours, the borrower defaulted a few EMIs, and the bank initiated SARFAESI proceedings under section 13 by issuing a notice. Now what happened is the borrower deposited the amount with the bank, the defaulted amount, before possession could be taken over. However, this did not stop the bank. The bank ultimately went ahead with the SARFAESI proceedings and took over the borrower's property, and in fact went to the extent of auctioning that to one sole auctioneer for half the price of the market value of the property. So this is a kind of situation where it is a pure conspiracy by the bank, and they are also protected under this act under section 32. So wherein the any act which is committed by the bank in good faith, there shall be no prosecution or suit which will lie against such a banker. Now the bank did not follow any guidelines under the SARFAESI, that is to give notice, 30 days notice in two leading newspapers, ascertain the market value, etc., etc. And primarily the bank could not have sold his property in a case where the borrower has deposited the money, repaid that amount. But as you can see, the NBFCs and banks can utilize this provision, and now even the cooperative societies can do that and misuse this particular provision. In another case, the bank charged a rate of interest as per its whims and fancies. It was floating rate of interest, and it started changing it and increased the number of EMIs without intimation to the borrower. Now, suddenly, when the borrower started questioning, he realized that the EMI also was miscalculated and the borrower was overpaying from the day one of obtaining the loan. Now, when the borrower objected to this high-handedness of the bank and stopped paying EMI, saying that you set it off, okay, what the bank did is they initiated proceedings under SARFAESI and ultimately knocked off this particular person's property. Now, the legislature's intent while incorporating Section 29, which the Ministry of Finance seeks to decriminalize, is that if any person, meaning even a bank official, if he contravenes or attempts to contravene any of the provisions of this act, then he should be liable to be punished. But the SARFAESI proceedings has been misused by some banks to make illegal profits. So my case is one of the first cases probably where we are seeking prosecution of these bank officials, and we have filed cases and under Section 29 to punish these officials for misusing this law. And like we are all aware of the number of scams which have taken place in the banks, and there are a lot of rotten apples in these banks, and these scams could not have happened without an insider involvement or without conspiracy of bank officials. So we have dealt with a lot of cases where banks and NBFCs have not followed the provisions of RBI and are free, while the borrowers are continuously being harassed by these banks, and some of them end up taking extreme steps like taking their life. So surprisingly, what happened in 2016 is this particular provision, penalties for non-compliance of direction of RBI. Now, one should note that RBI is the apex bank of the country, which actually gives guidelines to all the banks. Now, this particular section was omitted in the year 2016. So basically, the banks have a free hand to not follow RBI regulations itself. And that said, the RBI has absolutely no control over these banks, which they have admitted before several times during the PMC scam and the Nirav Modi scam. And there are no penalties for non-compliance also. So the borrowers are not protected at all. Okay, what if the banks are acting in an illegal manner? Shouldn't there be a provision which should protect these borrowers for against any illegal action? And if the banks are going to arm twist these borrowers, it is going to be fatal. Hence, in my opinion, this section does not help the foreign investors or domestic investors, neither does it ease doing business in India. This section purely assists the banks and financial institutions to arm twist the borrowers into paying, else they will initiate action against SARFAESI without any restrictions, without following the law or the guidelines of RBI. And all of this has been happening in spite of this section being there. So you can imagine that if section 29 is decriminalized, what can have actually happened? The banks will have a free hand to do whatever they want. Hence, decriminalization of this particular section must be opposed, otherwise it shall add another weapon to this draconian law, and the banks might end up misusing it against the borrowers. Similarly, the ministry has also sought to decriminalize Section 58B1 of the RBI Act along with 4A and 5, which basically deter any person or company to do banking business without following the provisions of the RBI Act. Now, in one particular case where there were certain prosecutions held under the RBI Act, and one particular case of Kerala High Court, wherein the accused was doing business in gold loans and without following the provisions of 45S of the RBI Act. Now, the accused was prosecuted for the same because this section 58B was available. Now, if this particular section is removed, it will any but person can do banking business without following the provisions of law, and people are so gullible in India that they will end up following these persons or companies which promise high returns. And in another case, Mohammad Firoz Khan was a state of Jharkhand. A person was doing non-banking business and collecting money under the garb that money invested in the company would double in 1 year. Now, this is something which is very common in India, and people fall for it left, right, and center. And decriminalizing this particular section would mean that the RBI will lose control over those persons performing banking business without following any guidelines. Again, there are not too many prosecutions as such under this particular act, and it does not help foreign investors or domestic investors, or it does not in any way ease doing business. Rather, it is an opening for fraud bankers and fraud banking institutions to operate. Therefore, it is my suggestion that there shouldn't be decriminalization of Section 58, subclause 1, 4A, and Section 58B5. Moving on, now the ministry has also sought to decriminalize Section 36 AD Clause 2 and Section 46 1 of the Banking Regulation Act. Now, I have gone through these provisions and I tried to look for case laws. Now, with respect to Section 36 AD of Banking Regulation Act, which reads punishments for certain activities in relation to banking companies. No person shall obstruct any person from lawfully entering or leaving any office, place or business of banking company or from carrying on any business there. Now the ministry seeks to decriminalize the second clause, which says that whoever contravenes any provision without any reasonable excuse shall be punishable with imprisonment for a term which may extend to 6 months, or with fine which may extend to 1000 rupees or both. Now I have gone through certain case laws pertaining to this section, and most of them pertain to protests held by banking employees, and even the number of cases which this particular section has been cited are very few. That said, I do not understand why the ministry is keen on decriminalizing this particular section. And now even section 46 of the act pertains to banking employees furnishing false statement or false return or balance sheet. This section, I believe, protects the banks rather than any industry or investor or any person as such. Therefore, I feel the ministry should rethink on its decisions to decriminalize some of these provisions. I'd be really happy to see your views and comments on the sections which I have discussed right now. And please guys, share this particular video, because awareness of these particular sections are very important, because most of the lawyers themselves do not practice under these particular sections, and decriminalizing these particular sections might have certain impact on the economy as a whole.